It's Fran McGovern, First Friday with Fran. Nice to see you. Madeline needs to be admitted. We got her. So I'm just going to go through the usual announcements, the kind of administrative stuff. Hi, Brenda. Nice to see you. Hi, Carrie. What do we have? So these webinars do not and cannot form an attorney-client relationship. We know that. Number two, educational purposes only. It is not legal advice. So this is not legal advice. This is just a discussion, just educational, just a seminar. If you want an attorney-client relationship, you got to reach out to us, a particular attorney, and sign a fee agreement with them. Get into a free agreement with them. And the last thing is, as you know, nothing will be kept confidential. So please don't tell us any secrets in the chat box or anything like that, or anything about any pending litigation that your association might be involved in, because everyone on the chat will see it, and it will be disclosed. So we have two super, super cute dogs of the day today. Have at it, Crystal. And this is Bowie. This is Bowie and Lexi. And Bowie is a 14-year-old Maltipoo, 14 years old. Neither of those dogs look to be 14-year-old. They're in great shape. And so it's Bowie's the 14-year-old, and Lexi is a 6-year-old Shih Tzu. So, and I don't know who Santa Claus is, but that is a really legit Santa Claus, too. So the dogs are owned by Stacy Homa, and Stacy works with New Jersey Realty Solutions. For those of you who don't know New Jersey Realty Solutions, they're a management company based in Audubon, New Jersey, and they've recently basically doubled in size. They took over Atlantic Realty, which is out of Atlantic County, New Jersey. So they are growing in the market, in the South Jersey market in particular. So Stacy wants everyone to know that Bowie is named after David Bowie, and Lexi is named after David Bowie's daughter. So when you know the name of David Bowie's daughter, you are a real Bowie fan. So thanks so much, Stacy, and we'll get right to the agenda here. So it's going to be a pretty short agenda today, although maybe like short, but like a little intense. So the first thing, this is Fran McGovern being a pedantic old man, being a preacher man for a bit. And that's because when I work out in the morning, I see these continuing reports of measles outbreaks, which is insane in this day and age, from my personal condominium association attorney opinion. Should not be happening, should not be happening. So please, please pass the word to everyone you know. Please speak. I am not a medical professional. I'm not a healthcare professional. I'm not even a Kennedy, but I'm going to give my opinion anyway, right? So please speak to your healthcare professionals about getting vaccinated, getting your family members vaccinated, getting children vaccinated, getting your grandchildren vaccinated. For the vast majority of people, it's appropriate. There are certain people with certain conditions that it's not appropriate for. And as you know, disease does not discriminate based on race, creed, color, national origin, sexual orientation, or any of those things. Okay, so please, you know, we all work in, not all of us, some of us are in single family home communities, but we work in the association field where we deal with high density housing oftentimes, especially in condominium associations, especially when they're flat style condos. It's high density housing where you have a lot of people around each other. And if you don't have proper vaccination or herd immunity, as they would call it in the medical field, you're going to wind up with an outbreak on your hands, and people are going to get sick and, or God forbid, die. Okay, so that's vaccination, nothing to do with COVID. But vaccines generally speak to your healthcare professionals who know something about that, rather than a condo attorney. But I do encourage everyone to do that. So FinCEN, the BOI reporting enforcement, is suspended. Why that is a little funky is the Treasury Department suspended the enforcement of it. But it's a little weird, right? Because we still have these cases pending. We still have cases pending. And there's a question of whether the Treasury Department has the authority to refuse, if you will, to enforce or modify something that is statutorily based, right? So there's this separation of powers issue. Does the executive branch have the power to refuse to enforce an act of Congress, regulations passed pursuant to them? So it's a little wonky right now because the court cases are continuing, but Treasury has said they're not enforcing, they're not posting fines, and they will be trying to pass new regulations addressing this. So again, not legal advice, but most of the people I see, if they have not filed already, are holding off, kind of pending what happens. In the latest actual deadline, as you know, that when it was still enforceable, if you will, was March 21st. But as I said, many associations, I think, that have not filed yet are just holding off to see what Treasury does in terms of the new reg. There was a question that came up after last month's meeting. Hey, Fran, if this thing is suspended and there's no enforcement and goes away because the Treasury has indicated that they're going to try to limit the registration requirement to foreign entities. If this goes away, what happens to our information? And that's a solid, I don't know, right? If we registered already, what happens to our information? They're going to delete it? Are they going to make it go away? What's going to happen? And we just don't know right now. So we'll see. It's still a bit of a struggle between the executive branch, the judicial branch, and the legislative branch of government. This is, like I said, during COVID, this is a great time for civics class in high school, to the extent civics classes still exist. Um, Hopefully they do, although sometimes it seems like they don't. But so right, so that's the BOI reporting at the moment. The next thing we have is a question that came up from last month's meeting to this month's meeting, and this relates to the structural inspection and reserve funding law, right? That everyone's been panicking about and setting their budget and getting reserve studies. And if you're a covered structure or a covered building, getting structural inspections and assessing people, and people are screaming at the boards and screaming at the engineers and so forth and so on. So there is a bill pending. So there's a bill pending, which is Senate 3852. And it's the identical bill, so people will say, no, Fran, it's two bills. Although technically it is two bills, there's one, a Senate Bill 3852. It's also the identical bill in the Assembly, which is a Assembly 5016. And the consensus seems to be that this bill is not going anywhere right now. It's a bill that's been introduced, but it's going to be the consensus seems to be it's going to be dead in the water. And the way you can, unless it gets some traction, the way you can generally tell that is it's not a bipartisan bill. And it's been all of the sponsors in both the Senate and the Assembly are Republicans, right? So that's not a good sign for things working their way through the legislature in New Jersey. What was the target of this bill? So this bill was to do two things. One, it wanted to limit the definition of a covered building to anything 3 stories or more in height, right? So if you were less than 3 stories, you would fall outside the requirements of the structural inspection and the funding. And it also wanted, to the extent of the reserve requirements, it wanted to limit the reserve requirements to only reserves required compulsory for primary load-bearing systems, right? As everyone knows, we've talked about this for the past several months. The reserve funding requirements apply to all of your items, maintenance reserve, repair and replacement for anything to the responsibility association. This bill seeks to strictly limit it to buildings over 3 stories, and also to limit the reserve requirements, the financial component. I shouldn't say over 3 stories, 3 stories or more in height. So, but limit the reserve requirement only to the funding of primary load-bearing systems, right? So I've spoken to several people in the industry. This is on the watch list for New Jersey Legislative Action Committee for CAI, so they are paying attention to this. But like I said, the consensus is it's not going anywhere. It's an interesting bill. Apparently, there are some other bills that I haven't seen yet. I've tried to find them that may be introduced that tweak the reserve requirements a little bit. But as far as I know, they have not been introduced yet, or they haven't moved forward yet. So there will be some things perking around legislatively in the New Jersey legislature And my understanding is there may be a bill that will clarify some of the language introduced by the Democratic side. So if something's introduced by the Democratic side, obviously that will be much more likely to move forward. That doesn't mean it's going to be adopted, but at least it would probably move forward in the legislature to some extent. The next thing I have is the mulch thing that Mike is going to primarily address, and I will jump in and out during Mike's discussion of the mulch topic. Go
Sure.
ahead.
Yeah. Thanks, everybody. Thanks, Fran. Mike Blulak here. So, if you haven't heard, last year in April, New Jersey amended its fire code across the state. So, this is coming from the state level to become effective 1 year later. So, that year is coming up, and that's on April 15th. And as it pertains to community associations, there's a provision in there that was changed, which is going to be a really big deal, perhaps, for most condo associations, some townhome associations, and to a limited extent, single-family homeowner associations. So what this revision pertains to is primarily the mulch. And it's a short section, so I'll read some of it here just so you understand what I'm talking about. The provision states that the use of combustible landscape materials, such as wood-based mulch products, is prohibited within 18 inches of any building or structure, all right, within 18 inches of any deck, porch, balcony, or portion of the building that's made of combustible material, and finally, within 18 inches of a designated smoking area. And the question is, what do we do then, right? So there's another provision that states this becomes effective on April 15th, 2025, so in about 5 weeks. And on that date, we must have removed mulch from 18 inches from the buildings. Now, there's a bit of an exclusion to this. So the New Jersey adopted the 2018 International Fire Code, okay? And the provision in there states that the fire code pertains only to all buildings except for single family owner occupied homes and multi-dwelling attached single family homes. So to get some clarity on this, because honestly, it's pretty confusing, we've reached out to the state fire marshal's office under the DCA, Division of Fire Safety, and spoke to one of the head people there. And what they were clarifying was that essentially this applies to all condo associations, because condo associations are not designated as single family homes that are attached. Rather, they're condos. So if you live in a condo association building, and there's a couple exceptions that I'll touch on, this is going to pertain to you. So you will have to have the mulch removed from 18 inches from all of the buildings and all of the porches and all of the balconies and everything else that is not fire resistant. Okay. The question becomes a little more complicated with townhomes. So technically, townhome associations are excluded from this because the International Fire Code states that single family attached dwellings are excluded from this provision. Becomes a little more wonky. You have some townhomes and some condo buildings that are exactly the same, but the ownership interest is different, right? They look the same, be right next to each other, sometimes in the same community. And some are designated as townhomes and some are designated as condos. And it's the state's position that this provision pertains to the condo buildings. It likely does not pertain to the townhome buildings unless the designation when it was built, and it would state in the certificate of occupancy for a unit there, whether it's an R5, which is a townhome, which means it wouldn't apply, or whether it's an R2, which is typically designated as a condo, which means it would apply. So if you're dealing with a townhome association, I would say let's take a closer look at this just to be sure before you spend a whole bunch of money, and have your landscapers remove the mulch, one, and then two, they suggest to put down either sand, or you can put down like a non-combustible mulch. That's like shredded tires, the rubber mulch, or you could put down rock within 18 inches of the buildings. but that's a pretty expensive proposition, right? So before we do that, we want to make sure it does apply to your community. And then I mentioned single family homes. Well, the individual single family homes are excluded, period. There's no question about that. The question, though, pertains to the clubhouse and the other ancillary buildings if you have them. And the answer is yes, it does apply to that. So your clubhouse will need to have the mulch pushed away from 18 inches. There's an exclusion though. There's a nuance to this. So, no, hey, Mark Stanziel, how you doing? So I was talking to Mark Stanziel earlier this week at Springfield Park Place. That community is a condo association, and they recently, or in the last whatever 6 or 7 years, pulled off the siding and put on hardy plank siding. And hardy siding is a concrete type material that is fire resistant, but it's a condo association. So I spoke to the state about this, and their interpretation is that in a condominium association that has a fire resistant siding would be excluded, generally speaking, except for the portions of the building that have wood or PVC. So let's say if you have a PVC pipe extending from the foundation, or some wood trim around a door, or a deck or patio or something with some wood on it, that would have to have the mulch pulled back. Okay, so there's been a lot of confusion over the last year with this. We've had some landscaping companies send out some blast emails, and there has been some conflicting information. But as it stands now, it does become effective on April 15th. It does apply to all condo associations unless you have a non-combustible siding. And even then, it would only apply where you have some combustible materials. Townhomes fall into the big question mark. It should not apply to the townhomes, but it could, depending on how they were designated when it was constructed. And then all communities, their clubhouses or ancillary buildings with mulch around it will have to have that mulch pulled back. And again, it's 18 inches. I have to imagine that all the landscaping companies in the industry are familiar with this. Again, it's a big deal and it's going to be really expensive. So if you haven't heard of this, or if you haven't looked into this yet or spoken to your landscaping companies about it, I would suggest you have that conversation. If you fall into the questionable category, reach out to us or your attorney and have them, if nothing else, pull a CO for one of the units there, and we can determine whether or not that building falls under the particular designation that would either provide for the exclusion or require compliance on that.
Yep. Yeah, thanks, Mike. So it's, as Mike said, it's continuing to be very, very confusing. And
Yeah.
even in the New Jersey Department of Community Affairs press release on this, it says owner occupied, the following are exempt from the new regulations. Owner occupied 1 and 2 family or attached single family structures used exclusively for dwelling purposes. Okay, so that would say, you would think that would mean 1 and 2 family owner occupied or attached single family structures. However, the code itself, when you click through to the language of the code itself only says, with the exception of owner occupied 1 and 2 family dwellings used exclusively for dwelling purposes. It doesn't say attached single family structures. So it's a little wonky still. And more importantly, in the release goes on to say in the section on the exemptions, it says the Division of Fire Safety strongly recommends following these provisions for safety reasons, even though these types of buildings are exempt from these provisions. That makes our life as association lawyers and your life as association board members and managers really, really difficult. The reason for that is, what if you're exempt, right? What if you're exempted, or what if you're questionably exempt? The mulch does not get pulled back. A fire happens, a mulch fire happens, the building burns, and God forbid someone's injured or dies, right? There's going to be an argument by a personal injury attorney that says, wait a second, we don't care if you're exempt or not. You were on notice and it was foreseeable that mulch fires happen, And mulch fires can burn the structure, right? Because you knew mulch was there. You may have been exempt from the regulation, which is fine. We don't care about the stupid regulation, but you knew, didn't you? Yes, I did. I knew this regulation was out there. Shouldn't you have done that anyway in the exercise of reasonable care? And I think that's a really dangerous argument for us because I don't know how many people have been involved in mulch fires. Many? Yeah, so we have one. There's Mark there. And I'm sure there's other. I know when my office was in a different office park and we had 2 or 3 mulch fires there where the mulch fires actually caught the landscaping on fire and the shrubbery went up too. The only saving grace was that the exterior of the building was parged with concrete. So it didn't catch the building. So but so that's the risk. And the case law in New Jersey with respect to foreseeability is pretty strong in favor of the plaintiffs, right? So we've talked about the dishwasher case before. So everyone knows there's this weird case in New Jersey where the pipeline connector behind the dishwasher broke and leaked down in the unit below. And the association said, not our problem. We had nothing to do with this. And the court said, well, yeah, that's nice, but you association had notice of that because that's a defect that goes on all of the washing machines throughout the community. And even though you may have not had the obligation to fix the person's dishwasher, you did have an obligation to put everyone in your community on notice of the hazard, right? Which I think is kind of a bad outcome, right? Because wait a second, the association is not responsible for the items in your unit, right? So the court went to great lengths to impose at least a duty to warn on the association. And I would be very concerned, given this regulation, if we had associations that even were arguably exempt, but left the mulch there, or even worse yet, installed new mulch within that 18-inch fire zone, right? Especially if there's combustible material. As Mike said, if you're up against concrete or non-combustible material, you're in a much different situation. But if it's there and near combustible material, I think you're going to have a problem even if you're exempt from the reg itself, because a personal injury attorney or an attorney who's going after the association for property damage is going to say, that was foreseeable. You shouldn't have put new mulch down. And in fact, you should have removed the old mulch and replaced it with stone. So that's the risk. So we would generally, again, not legal advice, we would generally discuss not putting down new mulch within the 18-inch zone regardless.
Mhm.
Um, and if you do have it in place within a reasonable amount of time, replacing it, pulling it back to the 18-inch zone. I know a lot of people are going to be like, Fran, that's crazy. The risk is it's not the reg, it's the risk of something bad happening and the association being sued. Okay.
And here's another like complicating factor to this. So the exclusion for the single family homes and attached single family homes applies only to owner occupied dwellings. So what happens if you have a townhome association in a building that has a couple rentals in the building? They are not owner occupied. And technically, like Fran says, if there's a fire and something horrible happens down the road, the exemption may not have applied to that building or particularly that unit. So this turns into one of these more likely safe than sorry, like Fran said, of removing the mulch or pulling it back or not putting new mulch in 18 inches, even if you might have an exemption.
Okay. So we have a bunch of people in the chat. The first comment we said, Janet says awe, and I guess that was for Santa Claus and the dogs. Thank you, Janet. Very cute dogs. The next one was Deanna. Deanna says she's agreeing. She's holding off. I'm sure that's with respect to the BOI reporting. They're going to hold off. Next one is Jeff Schiffman, always keeping us on our toes. Jeff, Mike, I don't know if you have the mulch reg in front of you. I don't have the mulch reg in front of me, but
I do, yeah.
he wants to say how, not just the 18 inches on the ground, but how high up must the non-combustible material go?
Yes. So there's two explanations here in the regs for the exemption, and I'll read it. It's just 2 sentences. So the first exception is for, and here's what it says, Jeff: live plant material such as shrubs, flowers, and trees, if not within 18 inches of the building or structure, or beneath a combustible overhang with less than 6 feet of clearance. In that situation, it's exempt, okay? And then also, another exception is for non-combustible building or structure exteriors that have no combustible components or trim with less than 3 feet clearance from grade. That is also exempt.
Right. So
So,
you'd have to have at least 3 feet up the wall, right?
correct.
Yeah. Okay. Let's see. So Mark says 12 months until they enforce. I don't think so, Mark. Mike, what do you think about that?
Yeah, so the 12 months pertain to when this originally passed. So
A
this
year
came
ago.
into effect a year ago.
Yeah.
So April 15th, 2024. So 12 months later is now. It's 5 weeks out from now. So it becomes effective and enforceable in 5 weeks.
Right. That's a good question, though, Mark. Has the DCA, who's this from? It's Bill Ferguson. Has DCA prepared for or developed a plan, rules, or other plans to enforce the reserve rules signed into law by Governor Murphy in January 2024? No, we haven't seen any DCA rules, regulations, or enforcement mechanisms. And as I said, what's going to happen here is the market's going to enforce it first, long before the DCA gets its regs out. It's going to enforce through mortgage underwriting. If you're not in compliance, I think the mortgage underwriters are going to starting to deny mortgages in your home, in your communities, and in insurance underwriting. We've talked about this before. I think insurance underwriters are going to either give you bad premiums or refuse to write your property if you're not complying with the law. So the third factor is there's a very high risk of civil liability, I think. The associations, people who buy into the association, especially after this law, and the association is not properly reserved for or funded, a new buyer is going to move in and sue when a special assessment comes or the assessments go up significantly to fund for a deficit. And they're going to argue that the association knew of the law, they didn't take the steps to do it, and now they're bearing the brunt of it because they didn't disclose it at closing when they purchased into the community. So I think we're going to see significant litigation coming out of this bill. Unfortunately, unless the law is amended. So you can, and there is a small exclusion from liability for engineers in the statute. That's generally off the top of my head, I think with respect to the structural inspection part. But the question is going to be, is there civil liability for board members individually? Is there civil liability for the professionals and vendors who work with those associations who are refusing or failing to comply? I have a feeling the answer is going to be, we don't know, but the plaintiff's attorneys will name everybody. They'll name the board members individually, they'll name the attorneys, they'll name the accountants, they'll name the engineers, on and on and on. So I think we're going to see significant litigation in this field over the next 2 to 5 years. Go ahead, Mike, you take next one.
Is there an exception for masonry structures? This pertains to the mulch regulation. So if it's a non-combustible structure, the mulch would not need to be pulled away from it. So generally speaking, masonry, non-combustible, you should be good. But again, back to the caveat to that, which is, let's say you have a door frame, a wooden door frame, or let's say you have a PVC pipe that extends from the foundation. That is a combustible item and would need to have the mulch removed from 18 inches from that.
Yeah.
Right.
So Vicky, I saw Vicky somewhere on here.
Yeah,
There
I
she is.
have
There
that.
she is. Yes, here. Yeah. Hey, Vicky. So Vicky says, I have a condo association that has 18 buildings, and each building has a mix of townhome style and over/under flats. What do you do with that? I think the best practice would be to pull back the mulch. I hate to say that, but I think best practice would be to pull back the mulch. The board is going to, wail and gnash its teeth over that, but I think that's the safest approach, especially given how unclear these regs are and how unclear the exemptions are, and especially as it relates to owner occupied versus tenant occupied. Most
And
most associations, you can't really tell, even though you have a lease resolution, which ones are owner occupied and which ones are not. It can be real tough. But
yeah,
thanks, Vicky. Go ahead, Mike.
and just a comment on that too. So, Vicky, if it is a condominium association, even though they're townhome style buildings, the determining factor, according to the state, is actually when the developer builds the place, the community is designated under a residential group R classification. So like an R2 is a condo association and R5 is a townhome association. So If the entire association is a R2 condominium, then it will absolutely apply to the entire community, even if they're townhome style. Okay, so and the certificate of occupancy on any unit would show that designation.
Okay, and so Julie says, what is the bill number? And I guess you're speaking about the proposal to change the reserve funding. You know what, I'm going to share, just so if people have never seen this resource, it's awesome. Let's see, where am I? Share this, share, everyone sees my little Google search bar there. Okay, so if you just go New Jersey Legislature, that's the New Jersey Legislature website. You click on that, New Jersey Legislature, it brings you to the New Jersey Legislature homepage. You just go to the bill section and go to bill search. And the bill number is on the agenda there, S3852. S3852. And we do submit. By the way, before I get there, the one thing you have to know about bills, bills go by legislative session. So if you see this box right here, it's the 2024-2025 legislative session. And what happens is bills that are in a prior legislative session, if they die, they have to be reintroduced in the new legislative session. So when we do this bill search, this is a current bill number. Sometimes as you move through legislative sessions, you have to find new numbers. But anyway, we hit submit. And there's the bill S3852, modifies requirements for associations to protect structural integrity of certain buildings, expands timeframes for associations to establish adequate reserves. So the other, I didn't mention this when we were discussing it before, but you know how the current reserve funding law provides for a 10-year catch-up period if you're under reserve? This proposal stretches that to 20 years for catch-up. There are a lot of nuances to that in terms of the funding, but this just gives you a good example. If you don't know the bill number, this is a lot more wonky in the state system. You can go by subject, you can go by the sponsor's name, you can go by keywords. It's a good resource. I just find it's pretty clunky if you don't know the bill number, because you wind up having to go through, pages and pages of bills. So we'll stop share there. Go ahead, Mike.
Is a decorative stone facing also excluded? Ours goes up one story. Generally speaking, I think the answer would be yes, as long as you don't have any combustible stuff sticking out anywhere. It should be all set, but I'll say perhaps it could depend. So somebody's gonna have to take a close look at the exterior facade to make sure that you don't have anything that is combustible. And the next one pertains to the mulch too. It says the shrubbery has to be taken out within the 18 inches, correct? Correct. So it's combustible landscaping materials. So any kind of landscaping material cannot be within 18 inches of the building.
Yep. So let's see. Next one, Mark says there's a question for Fran. Maybe I missed it, or maybe I got it already. I'll just move on to the next one. Mark, if you're still there, I think you're still there, and I'm missing your question. Just plug back in there and I'll get it. Kathy says, isn't it discrimination then? I don't know, Kathy. I don't know what topic that relates to, but if you put another question in there, I'll let you know. So everyone's heard my rant about discrimination. What you have to think about in terms of discrimination is legal discrimination versus illegal discrimination. There is legal discrimination, and we do that all the time, right? I like bananas, I don't like grapes. That's discrimination, but it's not illegal, right? But generally speaking, in the housing context and in most other contexts in the U.S., employment, et cetera, it's race, creed, color, national origin, sexual orientation, trans status, those types of things. And I'm speaking generally, some of those things are very nuanced depending on the context. So for example, under New Jersey state law, certain things may not be prohibited in terms of discrimination, but under federal law, they may be, they may be prohibited in terms of discrimination. So it's very nuanced. So, and you've heard me talk about this a lot in terms of discrimination. If anyone raises a discrimination claim in your community, immediately contact counsel, right, to figure out if it relates to illegal discrimination or it's just normal everyday discrimination. I like red cars instead of blue cars. That's fine. Um,
But Fran, so she put a note in the bottom. It said she was saying tenant versus owner occupied because the exemption is only for owner occupied.
Yes, that's right. So it is discrimination. In this context, I don't think it would be illegal. And the nuance in that comes up um, in terms of 5-year inspection exemptions as well, right? So there are certain exemptions under 5-year DCA inspections that are dependent on whether their units are owner occupied or tenant occupied. Um, I think maybe a good follow-up question would be, Fran, does any of this make sense? And the answer is no. No, right? Because if a fire is going to burn down your house, what difference does it make if a tenant's there or an owner's there, right? It doesn't make sense, right? So it's not well reasoned. And I don't know, maybe there are some nuanced reasons behind that. And as you know, making legislation is a sausage factory. You don't want to watch what goes into it. You just see what comes out on the other end. It may be that there were lobbying groups on behalf of owners, mortgage companies, et cetera, who said, hey, we want the owners excluded, and the tenant associations or the landlords associations did not have as strong lobbying groups. I don't know. But from a pure life, health, safety standpoint, it doesn't make sense to me to make a distinction between an owner occupied unit and a tenant occupied unit. So
Yep.
although it may not be illegal it may not be illegal discrimination. I'm not sure. I haven't done the research, but there's no common sense in it.
The next question says, what about cement block construction with vinyl coverings and some wood trim on garden style condo complex? So vinyl siding is certainly combustible, at
Yeah,
least according to the state. So
yeah.
I think you're going to have to pull it away, even though it's over cement block construction. I would suspect the answer would be yes. And if there's, by the way, this is all enforced locally by the municipality. So if there's questions about it, we can, pose them locally. Although careful what you ask for, but I guess.
Yep. So Julie says, shall we notify the homeowners? I guess this is with respect to mulch. So yeah, so she says yes. Should we notify the homeowners? I think it's a good idea, regardless, if you have the mulch within the area, to notify the homeowners before you pull it away. I think best practice would be to pull it away if the association is responsible for that type of landscaping. Um, but if it's going to be there for a little while, I would notify the homeowners, because many homeowners don't realize, and I didn't realize it, how combustible mulch can be until I walked outside of my office building one day and the mulch was on fire. Um, so I think it's good to let people know, because even though some mulch fires are spontaneous combustion, if you will, just the heat builds up and builds up, builds up. A lot of them are also cigarette butts, right? So if you throw a cigarette butt into a pile of really dry mulch or landscaping, it's going to go up as well. But mulch, even on its own, without the cigarette butt, it can go up on its own. And that's why you might see anyone who lives around a landscaping company and you see those giant mulch piles, they have those little mister hoses. You see the little misting hoses, misting devices that are constantly misting the mulch pile to prevent mulch fires in the landscaping lot. Go ahead, Mike.
The next question says, would it be advisable to have our local fire marshal visit our location to give an opinion? Um, to be honest, I think the answer is ultimately yes, although I'm always hesitant to get the township involved because once they're in it, right? So now they realize you're on the radar, and now that kids start to
Right.
give you a hard time. But
Yeah, it's like I forget which president said it. I think it was Reagan who said, you
yeah,
know, I'm from the government and I'm here to help.
right,
I think he might have been being sarcastic. So the risk, the beauty of it would be great, right? If the fire official came out, and my dealings with fire officials have been pretty good, I have to say. Um, but um, as Mike said, some are not so cool, and you don't want to come out and say, "Hey, it's awesome. You're going to be our first enforcement in case, right? We're
right.
slapping you with a violation, and then we're going to have per diem fines until you get this mulch pulled away by 18 inches." So the lawyer's answer has to be, "Yes, that's a great idea. but there's always the big but, there could be a downside to it.
Mhm.
Um,
Yeah, Alan said you answered the question about the 3-foot gap. Joanne asks, is this mulch issue just for New Jersey? As far as I'm concerned, the answer is yes. This was the New Jersey State Fire Code that was revised. So it applies to all of New Jersey.
right. And also, I don't know if you do work in other states, Joanne, but this was based on the International Fire Code, as Mike said, from 2018. So there's a pretty good chance if you're working in Pennsylvania or New York that it may have been incorporated as well. So if you think you have the issue in a different state, you should probably check it out. Can you unmute me for a question? Mark, where's Mark? Yeah, sure. You're not going to say something about Howard Stern, are you? Okay. Remember that in the 90s? People used to do that, call into shows and say, I love Howard Stern, right? Go ahead, Mark. Sorry.
Hey, first, thank you for putting this back on the agenda. It's extremely helpful. I posed a question in the chat. We're we're gonna mulch in April. Do we tell the landscapers to start now to pull it back the 18 inches? Or wait, they're suggesting we mulch. Listening to you guys, as you know, we always take your guidance. I'm not comfortable in that. I
I
don't
would,
like
I would,
Big
I would,
Brother
I would,
showing up on a property.
yeah, I'd be hesitant to do it, Mark, honestly.
Yeah, Mark, I think technically you have an exemption because of the hardy plank siding, but there's a but there. Again, it's local enforcement. So the local fire marshal is going to make the determining, the call on whether or not they're going to try to enforce it. We may want to get an opinion from them if you're going to mulch, but at the same time, it's probably better to be safe than sorry and just not mulch up to the 18 inches for the building. I think that was
On the
the best way to go
exemption
about it.
side, or the hot spots, which I'll call the decks, the PVC piping, yada yada yada.
Yeah, without question, all of that cannot have mulch within 18 inches.
Okay.
Mhm.
Should we be proactive with the vegetation, and some of the vegetation is closer to the siding than 18 inches, or just cut that back? I I know you guys don't have an answer. It's just we have to give them direction going forward because we're going into spring.
Sure.
The most conservative would be to pull it back, right? So no attorney, regardless. I mean, I know we work together, Mark, but no attorney is going to be like, yeah, don't worry about it. It's not a problem, right? No attorney is going to say that because, again, worst case scenario, a fire happens and bad things go down. You see what I'm saying? So
Yeah, no, I know, and I understand that, Frank, Fran, and we've always taken your guidance.
There was a question Jeff had, friend, and you want to take this as, would it be advisable for a community that needs to ramp up the reserve contribution over a period of years to have the board pass a resolution stating that this is the plan?
let's see. I think the answer is yes, if it's compliant with the statute. Right? If it's compliant with the statute, if it's compliant with the catch-up provisions, if you've gotten the reserve studies and all those other good things, right? Because my understanding is, and I don't have it in front of me right now, that the catch-up provision was applicable to associations that were already in a funding plan, right? And they didn't get a new reserve study. But if they had an existing reserve study, they could catch up over a 10-year period. If they got a brand new reserve study, in theory, they could, they not could, were required to fund that plan under the new reserve study, which really kind of takes catch up off the table. Jeff, you see what I'm saying? Yeah, you go ahead. I'm gonna unmute you, Jeff, at great risk to myself.
What about the provision that said if your increase is over 20% or of the capital reserve funding, that you can ramp it up over the years?
Yes, and I don't have it in front of you. My interpretation of that at the time was that it applied to existing reserve studies, because in theory, a new reserve study should capture all of that, right? I mean, we could talk about it more offline, but in theory, a new reserve study would capture all of that.
Yeah, and Jeff, there's a provision in that statute right after actually in the same paragraph where it talks about the 10-year catch-up, which states that it can exceed 10% of the budget if necessary, suggesting that it's really just for the catch-up, that 10-year period. So
Julie had a clarification. She says the association only mulches common areas, but homeowners mulch foundation areas. Do we have to tell them to remove it? Do you have to tell them to remove it? I'd have to look at that question more carefully, Julie, but I would say it's again, best practice probably to tell them to remove it. Yes. You'd have to get involved in probably passing a board resolution. It would almost be like an architectural resolution that specifies how people must landscape, right? So I think it'll be best practice for sure.
there's a question that says, can this be taken from the reserves to cover the cost? I presume that's talking about the mulch.
Yep.
Yep. And
The answer
go
is
ahead,
no.
Fran. You go ahead.
Yeah,
exactly.
the answer is, that's a short one. The answer is no. I'm sorry.
There's a question that says, we have cement and brick walls. That would be okay, correct? Again, generally speaking, yes, except where you have things like, I don't know, wood trim or PVC pipe that's exposed.
Yep.
Should fall under the exemption, but again, go back to what we talked about. I think the safe practice is probably going to be to pull it away.
Right.
Let's tell you that.
Kevin Myers says, Baba Booey. Kevin, I might just have to blow smoke out my eyes for you. That's a reference to Howard Stern's old shows. Thanks, Kevin. Go ahead, Mike.
Yeah, for clarity, did you say shrubbery was also included? Yes, that's correct. Meaning that any plants need to be removed other than perhaps flowers. Yeah, so landscaping materials can't be within 18 inches of the combustible surface.
Right. Same thing, Alan. You have the next question down. Same thing. It
Yeah.
should be trimmed back. Yes. So Dawn says, I'll read it and then we'll see we got it. Mulch, how does this apply to exceptions? Live plant materials such as shrubs, flowers, and trees, provided that they are not beneath a combustible overhang with less than 6 feet of clearance. Yep. Is that saying that you, 1 second, something happened there. Is that saying that you can mulch shrub beds next to a building as long as there's not an overhang? No. Go ahead, Mike. It probably be easier for Mike to read the rule again.
Yeah, I think it's still nothing within 18 inches of a combustible surface.
Right, that's right. It's not just an overhang, right? It's combustible surface. So siding, think about it like vinyl siding, thinking about it, cedar siding, things like that, things that are going to burn. They want everything away from things that are going to burn. Bill says, on a reserve study, you expressed opinion. There may be many lawsuits over the next few years and trustees may be named. In a co-op, the certificate holder lists and sells their proprietary lease certificate. There is an 8-page disclosure realtor document that I had to complete when I sold my home in Bergen County. If the co-op board completed this document prior to allowing the listing of the proprietary lease certificate, would that reduce lawsuit liability? So I don't know how I'm interpreting this, Bill, but what I would say the touchstone for all of this is disclosure, disclosure, disclosure on reserves, disclosure, disclosure, disclosure. And Bill, if you were here, I think it was last month, I talked about this briefly, and then I talked about it for a while, probably about 6 months ago. The regulations on realtors, in my opinion, have put an increased burden on realtors to disclose this type of information, whether the association is properly reserved for, whether the association is compliant with the statute regarding structural inspections, because this is commonly known information now, right? So I think disclosure is important, but obviously compliance is much more important. So disclosure is the touchstone of any real estate transaction, but compliance is more important when it comes to liability. Just to give you an example, I was at an associate, I think it was Manalapan. I was at an association meeting in Manalapan recently after the new year, and we were talking about a situation where the association is going to have to assess about $14,000 per unit to do the siding and the roof. And we were going through pictures. We had engineers there, the whole show. And after the meeting was over, the meeting went very well. The people understood what was going on. after the meeting was over, a young couple came up to me and said, "Hey, Mr. McGovern, we just moved in. We just moved into this community, and you're telling us we're going to get hit with a $14,000 assessment." And I said, I apologize. I'm sorry. I don't know what to tell you. And she said, "But yeah, what you also said is that the association has been working on this for some time." And I said, "It has, because I can't lie to them." And they said, "Well, who can we sue?" That was their first words out of their mouth. "Who can we sue?" And I said, "I don't know. I can't tell you that. I'm the association's lawyer." As you might imagine, they had a realtor at the closing. The seller, I'm sure, had an obligation to say something if they were aware of this information, which I imagine they were. And I'm not saying it's a viable claim, but I think those are the type of claims you're going to have. New couple moves in, new people move in, and they say, "Wait a second. The seller didn't tell me, the realtor didn't tell me, the property manager didn't tell me, board members didn't tell me. There was a closing certificate that had all kinds of information on there and didn't tell me." And everyone knew that the reserves were underfunded and this was coming down the pike. And now I'm getting hit for it. So I think that's where the biggest issue is, in addition to the insurance underwriting and the mortgage underwriting.
All right, and last question here. It just says, what's the normal procedure to change parts of the governing documents as it relates to some of these topics? There's a handful of ways to do it, depending on whether something in your bylaws or your master deed or declaration of restrictive covenants needs to be amended. So if there's a particular issue, reach out and we can let you know whether the board can amend to comply with changes in the law, or whether the membership needs to vote on an amendment, or whether you can use the rejection ballot method where the board passes it and then it's mailed to the members and then they have an opportunity to reject. So there's several different options, and we can kind of walk you through or talk to your counsel if we don't represent that association.
Yep. So that's about it. It's great seeing everybody. It's sunny and nice out there. Hopefully the wind has died down a little bit, and we will see you next month. Thanks again for attending. We appreciate all of you. Thanks so much for showing up. See you next time.